Welcome and thank you for your patience. My name is Catherine Williams and I'm Research Director at the Centre for Public Integrity. On behalf of the Centre and the Alliance Against Political Prosecutions, thank you for being here with us today from wherever you might be joining. I am joining you from the country of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past, present and emerging. We are here today to talk about secret trials, political prosecutions, and the treatment of those who have the courage to speak out in the face of wrongdoing. People like Bernard Collaery, Witness K, David McBride, and Richard Boyle. It might be with some incredulity that we find ourselves here confronting issues that are anathema to our system of justice, to the rule of law. And yet we are here. Amongst the reasons for this, we are here because we have a National Security Information Act that enshrines the precedence of the Attorney General's view about prejudice to national security over other considerations, including the defendant's right to a fair trial. We are here because we have a Public Interest Disclosure Act that is not fit for purpose. And we are here because it has been determined that some deeply questionable conception of the public interest is served by the pursuit of the prosecution of whistleblowers. We're very fortunate today to be joined by Bernard Collaery, Stephen Charles, and Pauline Wright. We are first going to hear from Stephen Charles, who, after being appointed Queen's Counsel in 1975, served as chairman of the Victorian Bar and that bar's Ethics Committee, as well as president of the Australian Bar Association. In 1995, he was appointed a foundation judge on Victoria's Court of Appeal, where he served until his retirement in 2006. In 2017, Stephen was made an Officer of the Order of Australia for distinguished service to the law and the judiciary. He serves as a board member of the Accountability Roundtable and has served as a board member of the Centre for Public Integrity since the Centre's inception. And we're the very fortunate beneficiaries of the generosity with which he shares his time, intellect, and commitment to advancing justice in this country. Stephen, thank you. Stephen, you're muted, unfortunately.
Sorry, Catherine.
No, you're right.
The secret trials that we want to discuss today are those of Bernard Collaery and Witness K. They arise out of the dispute between Australia and Timor-Leste in relation to the oil and gas fields in the Timor Sea, which are very much closer to the coast of Timor than they are to Australia. And negotiations that have been proceeding for a very long time between Australia and Timor as to the line, the median line that should divide control of various parts of the Timor Sea. Now, the oil and gas fields, the Sunrise fields, are fairly close to the Timorese border, and Australia was negotiating with Timor about this in the early 2000s. At that time, Timor, not long a separate and sovereign country, had assistance from Australia under AusAid for the construction of a number of important buildings, including the building in which their cabinet rooms were kept. Unbeknown to the Timorese, AusAid workers, who included ASIS agents, had installed bugs in those cabinet rooms, which meant that during negotiations between Australia and Timor, our negotiating team was being informed by those bugs of the views and the attitudes of the Timorese. These matters are allegations. They have never been admitted by the Australian government or ASIS, but they are allegations which remain undenied, and which there are plenty of reasons to assume their truth. Why otherwise would ASIA's agent now be being prosecuted for releasing secret information? Now, when Australia attained a very satisfactory treaty with the Timorese, it led to most of the revenues coming from oil and gas in the Timor Sea going to Australia. Something like 2013, the ASIS agent went to Bernard Collaery and told him of the existence of these bugs, and the Timorese began proceedings in the international court to void the then existing treaty, which gave Australia so much of an advantage. After starting those proceedings, the Australian government sent in ASIO agents and the federal police into Mr. Collaery's offices, and where they seized the advice that Mr. Kaleri had prepared for the Timorese, the first affidavit of witness K, which was to be put before the international court, and they seized witness K's passport to prevent him travelling to The Hague to give evidence. Now, in the first place, one can tell very rapidly the enormous advantage that one side in negotiations has when it knows the precise details of their other parties' beliefs and attitudes to the matter in dispute. That means that if Australia had that advantage, it was guilty of contractual fraud, and the contract was likely to be, the contract leading to the treaty would mean that the treaty was likely to be set aside. Now, the invasion of Mr. Collaery's offices by ASIO's agent was then the invasion of foreign territory. Mr. Collaery's offices were at that stage the property of sovereign territory of Timor. It was a breach of international law. It was also, quite basically, a criminal trespass, and the activities were a flagrant invasion of legal professional privilege. They also amounted to the most appalling contempt of the international court at that time. We Australians pride ourselves on living under the rule of law. Our government at that stage was trampling across the rule of law in every possible direction. Now, that led to the treaty being set aside after proceedings in the international court, at which stage the attitude of the 17 judges of the international court was evident from the fact that when our Solicitor General offered undertakings as to how the documents seized would be kept sealed and protected, the court was unwilling to accept our Solicitor General's undertaking and instead imposed direct orders on Australia requiring that. The next stage then is that after these matters had been allowed to lie on Mr. Brandis's desk for some considerable time, after the new Attorney General, Mr. Porter, took office, he signed the certificate which allowed these proceedings to start, and later a second certificate which required them to be conducted in secret. Now, the first question of the certificate allowing these proceedings to start has been challenged, but unsuccessfully, but it requires an exercise in decision-making which is extraordinary. It is difficult to imagine something which could be more inevitably to arouse international opinion about Australia's behaviour than to start prosecutions of whistleblowers telling the world of Australia's appalling behaviour. This, no doubt, would be one of the reasons why our Attorney General wanted to keep these matters secret. As to why he would start these proceedings, no doubt he was being told by those in the security services that it's essential to keep Australia's secrets in such a trial. At the same time, he would no doubt also have been very anxious to keep from the eyes of the public as far as possible the nefarious behaviour of those in our government services who were involved in the bugging of the Timorese cabinet rooms and in the use of material obtained from them. Now, the next step is once you start proceedings of this kind, there would be an obligation on the prosecution to be fair. One would call that obligation the obligation on the Commonwealth, as the prosecutor here, to be a model litigant. And in this case, the prosecution and the Attorney General's Department has been anything but a model litigant. Let me give you two examples. In the first case, the Commonwealth has spent millions of dollars on this prosecution, millions of dollars, gaining assistance from expert evidence overseas and matters of that kind. Both witness K and Mr. Kaleri are not rich people. They have struggled to obtain a decent representation. And I know from discussing matters with witness K's Silk and Junior and their solicitor that all of them have acted pro bono in this matter for at least the last 2 years. At the same time, they've been unable, in the absence of the millions of dollars which the prosecution has spent, to gain expert advice along the way, which they have hoped to do. They have asked for legal aid, and until the very last minute were denied any, bearing in mind a Commonwealth prosecution with millions of dollars to spend, and these defendants with very little indeed other than their houses. Now, the result, in my view, is the likelihood of an unfair trial, because, and as the High Court has said, in a situation of that kind, and the best known example is Dietrich's case, that such a trial should not start. But it was only at the very last minute that a meagre sum, less than $100,000, was offered in legal aid to these two accused. That is appalling. But beyond that, in matters such as the decision to maintain the absolute secrecy of this trial, then at the last minute, after witness K had reached a situation where he could pursue his defense any longer, and at which point he agreed to plead guilty and has been dealt with, then the situation arose of the secrecy of the trial, which Mr. Kaleri was to face. And in that situation, it was at that point that Brett Walker, SC, offered to assist Mr. Kaleri in his defence. Mr. Kaleri's solicitors approached the Attorney General's Department, as they had to, and asked for permission to add Mr. Walker to the list of counsel. And you will find in a judgment which is now available, it's Kaleri and the Queen, 2001, ACTCA. If you care to read that in particular, paragraphs 17 to 19, you will find that the Attorney General's consent was delayed until the very last minute, and the only possible reason for that could have been to make it, if possible for them, to avoid Mr. Walker appearing on Mr. Kaleri's behalf. Read the judgment if you wish to see that, and the unfairness of the attitude being shown. The result of all these things is that the Australian government's performance throughout this matter in our dealings with our poorest neighbour is one of mendacity, duplicity, fraud, criminal misbehaviour, invasions of legal professional privilege, contempt of court, denial of a fair trial, and a failure to act as a model litigant. Thank you.
Thank you, Stephen, for that excellent overview of the many troubling matters associated with these cases. We are next going to hear from Bernard Collaery, who at this point requires little introduction. Suffice to say that Bernard is a former ACT Attorney General who in 2018, along with his client, witness K, was charged in relation to the Australian government's bugging of Timor-Leste government officers during negotiations over the Timor Sea oil and gas resources, an act not only morally reprehensible, but also likely unlawful. Bernard, thank you. Now, Bernard, you're muted at the moment.
Thank you. Thank you, Catherine. I must say I'm honoured to be on the same panel with former Justice Stephen Charles and former President of the Law Council of Australia, Pauline Wright. There's not a lot I want to say because I'm a person under trial at the moment and I need to be appropriately discreet and sensible to the concerns of the court and justice. But I just want to, Catherine, if I may, give some background to some issues. You can guess why I'm so interested nowadays in the conjunction between adjudication by the courts and policy and political considerations. I mean, that stands out from what Stephen just said. But there's some great ironies in this. I was mentored at law school by Professor Julius Stone. He, for reasons, took an interest in me, and I guess he had a formative effect on my outlook on the law and the rule of law. But I did tell him at one stage late in my law school education that I was sick of washing dishes in the Swiss Inn at King's Cross, and I'd got a job in the Commonwealth Public Service, and I'd been moved quite quickly into a particularly interesting area that related to security concerns. I won't go into that. And I told him that I've got this job. And his reaction was, well, that's good. You got married too early. You've got a child in a one-room flat, and you better get a Commonwealth salary, which I was drawing, paid from Canberra, of course. And he said, but I want you to be careful in your work of overreach. You're a lawyer above all, or you will be. You'll be admitted shortly, and be careful of overreach. And he said, I want you to read Zelman Cohen. I think they were parallel figures at the time. I think they got on well together. Sir Zelman Cohen, as we know him. I want you to read Zelman Cohen's reflections on Sir John Latham, former Chief Justice of the High Court. He said, that's a study in constancy and outlook by the courts, and it's a study in how policy and political considerations interact with our profession and the practice of law and the activity of judges. And so I actually went and bought that book, and I found it the other day in my library. Its pristine condition suggests that I don't think I took much notice of what Professor said, but I opened it up and I did read Cohen's reflections on Sir John Latham's time in the High Court. And of course, he joined a politically divided court in the Depression. And after he finished being Federal Attorney General, and he was joined shortly thereafter after the appointment by Labor of Evatt and McTiernan. And so the court was an interesting mix, just to put it neutrally. But Zelman Cohen says, and I just I read what he concluded. It was natural that Sir John wanted to, was really at pains to insist on black letter law, legalism, and the legal character of the court's function rather than other issues. But what Cohen isolated was what he thought was a notorious comment in what we call the first uniform tax case. And that was what the Chief Justice said. And those words were, the controversy before the court is a legal controversy, not a political controversy. It's not for this or any court to prescribe policy or to seek to give effect to any views or opinions upon policy. We have nothing to do with the wisdom or expediency of legislation. Such questions are for parliaments and the people. I suspect he was speaking to his colleagues as much as the rest of the court and the people of Australia. But Zelman Cohen goes through his judgments to indicate how difficult it was during the war for Latham, because he was very much taken with the dire condition that Australia was in. And what came before the court were a number of cases that spoke of the determinations by the authorities, particularly the Attorney General, that some conduct might prejudice national security. So there's nothing new about that terminology that comes out of my case. It went right through the war and of course reappeared during the Korean War with the Communist Party Dissolution Act. And you will, if you read some of Sir John's judgments, particularly his lone dissent in the Communist Party case, you'll see that he almost completely contradicted what he'd said in the uniform tax case at the beginning of his career on the bench. So the great problem for our society is this: if the executive are not behaving lawfully as the one of the three-part separation of powers, and if the parliament isn't reining them in, should the judiciary do that? And for the judiciary to do that, what does it have to abandon in terms of those elements that Sir John Latham said? So they are profound issues. They bespeak of that troubling circumstance when there is a perceived emergency that drives an executive. In the war, in the Second World War, that was not perceived. It was a very real emergency. But during the Cold War, people were charged with sedition, and I think Sir John gave the casting vote in the Brown case, where Brown had spoken some seditious words in Hyde Park, I think, allegedly seditious words. He was a communist, an avowed communist, and Sir John, on an evenly divided court, did the casting vote to convict him of sedition. History teaches us lessons, and Catherine, it's easier for me in the situation I'm in to speak of history than current history. But just those words of Julius Stone now ring in my ears when he talked about be careful of overreach. Some of my children talk about karma, but we won't go into that. But I think that we face an extremely challenging time, and the we includes the courts, we in the legal profession, and we the people. It's an immensely challenging time and a very worrying time. There's one other allusion, and I'll quieten down. At the time witness Kay saw me, I was spending time with the St. James Ethics Centre. We were working in our region in Asia in a non-state to state function where we were bringing young Australian leaders, some of whom are very eminent persons now, and young and not so young leaders in Vietnam Indonesia, Malaysia, and Cambodia, and other places, Thailand. And you can imagine how I felt about intoning the ethics that Stephen Charles speaks of after Witness K was approved and came to see me. Life sometimes presents massive and monstrous challenges to us in our profession. We get them from time to time, but I think looking back over 40, 50 years, I'm involved in one of the greatest ethical challenges of my life. Thanks, Catherine.
Thank you very much, Bernard. I'm sure I speak for all of us here when I say that I hope that you'll very soon be able to speak about more current history also, but how very prescient the warning to you to be careful of overreach turned out to be. I recall reading, Bernard, that one of the things that has given you comfort throughout this ordeal has been the support of the Australian legal community. And we're next going to hear from one of the leaders of that community, Pauline Wright. Pauline is president of the New South Wales Council for Civil Liberties. She is the immediate past president of the Law Council of Australia, as well as a past president of the Law Society of New South Wales. Throughout her appointments, Pauline has been a powerful advocate for open justice and the upholding of the rule of law. Pauline, thank you.
Thanks very much, Catherine. And Yama, greetings from Darkinjung country on the New South Wales Central Coast. I'd like to pay my respects to the Darkinjung elders, past and present, and to the First Nations youth of Australia, in whose hands is held our hope as a nation for a reconciled future. You're right, Catherine, that the legal profession has supported Bernard Collaery throughout this, because the egregious nature of the way he's been treated is something that should concern all of us, and it certainly does concern the legal profession. There are a number of civil liberty and rule of law concerns raised by the prosecutions of Witness K as well as Bernard Collaery, including freedom of speech in the public interest, open justice, abuse of the notion of national security, the rule of law, the notion that everyone's equal before the law and no one is above the law, as well as the independence of the legal profession. So I'll turn to each of those topics in turn. Firstly, freedom of speech in the public interest. As we've heard, both Witness K and Bernard have been charged under Section 39 of the Intelligence Services Act, and that deems it a criminal offence for a person to communicate any information that was prepared by the Australian Secret Intelligence Service in pursuit of its functions. And here we have two people who told the truth in the public interest about Australia's deplorable and probably illegal bugging of a friendly nation for commercial gain. Instead of the perpetrators of the initial wrongdoing, it's the individuals who exposed it who are being prosecuted. Witness K has been convicted and given a 3-month suspended sentence and a 12-month good behaviour bond, while Bernard, a highly regarded member of the legal profession, potentially faces 2 years jail. A law that prohibits the disclosure of an illegal act by a public authority may infringe the freedom of political communication, which has been held by the High Court as being implied into our Constitution in certain circumstances. If this case does go to the High Court, it will be interesting indeed to see what and whether the High Court will have to say about that. The New South Wales Council for Civil Liberties, along with the legal profession, has been calling for a public interest defence to Section 39 charges where a person is disclosing information, even if it does pertain to national security, where that disclosure is in the public interest, and especially where, as in this case, apparently an illegal act is being disclosed. So let's turn to open justice. The National Security Information Criminal Civil Proceedings Act of 2004 requires these kinds of cases to be conducted behind closed doors in certain circumstances. Now that offends the principles of open justice. It's a basic rule of the common law and a fundamental attribute of a fair trial that the administration of justice should not take place behind closed doors. It must take place in an open court if we're to have confidence in it. If Bernard Collaery is convicted in a closed court, when not only members of the public, but also his lawyers and the jury are denied access to substantial parts of the evidence, then public confidence in the administration of justice is going to take a beating. As Richard Ackland, a legal journalist, of course, put it recently, confidence is already a delicate flower. Judges and courts only have authority and community acceptance if justice is seen to be done, if reasons are explained openly, and if fairness is the guiding principle. And he's right. Public faith in the administration of justice requires that justice must not only be done, but it must be seen to be done. Secrecy or suppression is only ever appropriate in certain carefully considered exceptional cases. The avoidance of political embarrassment is not sufficient justification to warrant secrecy. And to date, the government has given no adequate evidence of any credible threat to Australia's national security if Bernard's case were heard openly. Indeed, in the ACT Court of Appeal recent decision in October, in Bernard Collaery's case, based on the case notes that we have, at the moment the judgment is still not available, and it won't be available until the government, until the Attorney General redacts those sections of it that it deems appropriate. So we might not see that for some time. But in any event, the case notes indicate that while the court found that while there was some risk to national security by the disclosure of information, that risk was unlikely to materialise. But on the other hand, the Court of Appeal found that there was a very real risk of damage to public confidence in the administration of justice if the evidence could not be publicly disclosed. The Australian public, if not the world public, is already aware that Australian spies are alleged to have bugged the officers of Timor-Leste, probably and most likely contrary to international law, in order to gain the upper hand over this relatively powerless, impoverished and friendly nation in negotiating that lucrative oil and gas deal for commercial advantage of our government. There's been no indication of any truly significant national security issue to be served here, other than the present coalition government wishing to cover the Howard-era coalition government's tracks. It's been said that if the government doesn't want to be embarrassed about its activities, it ought not do embarrassing things. And if it does, those things deserve to be exposed. As Stephen Charles said in 2013, this all arose where Timor-Leste made the complaint about the Australian surveillance operation and the legal and commercial disadvantage that it had suffered to the Permanent Court of Arbitration in The Hague. And it briefed Bernard to represent its interests, and witness K was invited to give the evidence. Bernard interviewed witness K in the usual way, in a way that no doubt he has for his whole career, spanning almost half a century. If interviewing a witness or a client in this way for the purpose of giving lawful advice was conspiracy, it means that he and many other lawyers are guilty of conspiracy for merely doing their jobs if they might receive information from privileged sources. That is just not acceptable in Australia, in a liberal democracy. And as Stephen has said, the then Attorney General George Brandis ordered the confiscation of witness K's passport to prevent him giving evidence in The Hague, and ordered the ASIO raids on the homes and offices of both witness K and Kaleri. The raid on Bernard's premises, in legal terms, was nothing short of scandalous, because it enabled the seizure of that affidavit he'd drafted, summarising the whole case that Timor-Leste was going to present to the court. One party, abusing its executive power when it's got it, as the government does, to obtain the upper hand in international legal proceedings is just a scandal. Brandis then notified witness Kay and Bernard that they may be prosecuted, but he declined to take that action, and nothing happened until 2018, as Stephen has outlined, when the then new Attorney General, Christian Porter, decided to commence the proceedings. And the rest, they say, as they say, is history. There was a glimmer of hope after Michaelia Cash replaced Christian Porter as Attorney General, and her lawyers indicated in February this year in the witness K proceedings that it wasn't their aim to devise a regime that would see the court automatically closed whenever sensitive information was likely to be discussed, saying that the Commonwealth wanted to keep proceedings as open as possible. But there's been no sign of a new, more open approach in Bernard Collaery's case, including at that hearing in May 2021. The federal government has had to be forced, kicking and screaming, to consider holding partially open proceedings due to the Court of Appeal decision upholding Bernard's appeal against the non-disclosure orders made on the 26th of June 2020 on the application of former Attorney General Christian Porter. It of course is a great relief to see Bernard Collaery winning his bid to overturn that ruling, which would have seen most of his trial shrouded in secrecy. And the ACT Court of Appeal reaffirming the importance of open justice was really reassuring. The importance of it in deterring political prosecutions, allowing the public to scrutinise the actions of prosecutors, and permitting the public to properly assess the conduct of the accused person. All of those things, according to the case summary, were things that weighed on the court's mind. The matter is now going to be remitted back to the primary judge to consider the admissibility and effect of some further affidavits from the Commonwealth Attorney General, which have yet to be disclosed to Bernard's legal team. That ruling means that, subject to any impact that these affidavits might have, there may be public disclosure of information relating to the truth of the matters identified by Bernard Collaery's team as not requiring secrecy, and they're called the identified matters. But there's the rub. Depending on the primary judge's consideration of the impact of these as yet unseen affidavits, the identified matters may still not be able to be disclosed. If the judge considers that what is in the affidavits means that disclosure of the identified matters will have an unacceptable impact on national security, then Bernard Collaery will be back to square one and the trial will remain secret. So that brings us to the notion of national security and how our current crop of politicians in federal government are misusing it to suit their political agenda. Bernard Collaery and witness K are just two of many being persecuted under some of the most draconian anti-terrorist security laws in the world, passed in Australia post 9/11 with the support of both the Coalition and Labor. The recent misuse of anti-terrorism laws against the friendly Geordies to deal with unwelcome journalistic probing and cynically labelling national cabinet discussions as cabinet in confidence to avoid scrutiny during COVID-19 are examples of the pattern of suppressing transparency in government activities that have become common, and increasingly so, and disturbingly so. National security should be about our safety as a people and protecting Australians from threats such as terrorism. It shouldn't be used as a means of saving face when bad behaviour by our government for commercial gain comes to light. The bugging of Timor-Leste has been dubbed Australia's Watergate and raises real questions about how nations use spies to further their commercial interests. The misconduct complained of arose from a culture that was motivated entirely by commercial interests, unrelated and arguably contrary to Australia's national security interests. It's been reported that this was early in the day, that Australia's military were angered or surprised at least by the spying operation. Admiral Chris Barry, former chief of the Australian Defence Force, who planned, directed and commanded the operation to secure Timor-Leste after widespread militia-led violence, was certainly surprised by the decision to plant surveillance devices in the cabinet rooms, saying, it's a bit extraordinary, isn't it? On one hand, you conduct a security operation to establish a new country in this part of the world, and then a few years later, you're up to these sorts of shenanigans. Retired Major General Peter Phillips, former national president of the RSL, said, in terms of bugging the Timor Cabinet Office, I thought that was way beyond what we would expect of our intelligence services. I still can't see what it has to do with national security. And as Peter Galbraith, former American diplomat and lead negotiator for East Timor during treaty talks with Australia, observed, what is clear is Australia was not doing this for national security reasons. It was doing it for its commercial interests, to help the oil companies and to secure additional revenue for the Treasury. Under the laws applying to Australia, there is nothing that permits our government to take actions that are contrary to Australian law or the law of another country. This is consistent with our common understanding of the rule of law. It's likely that ASIS was committing a criminal trespass in a friendly nation, and a regional ally in Timor-Leste, when it bugged their cabinet meetings which by law are secret, as in every other democracy. And in raiding Bernard Collaery's office and seizing documents, ASIO were in fact confiscating documents belonging to another nation, contrary to international law. The UN Convention on the Jurisdictional Immunity of States explicitly provides that nations and their property are immune from the domestic jurisdiction of other countries. By confiscating Bernard Collaery's legal advice to the Timor-Leste government, Australia violated this principle, quite apart from egregiously breaching the principle of legal professional privilege. None of this can be in Australia's long-term national interest, whether in terms of security or commerce. Will not be considered a trustworthy nation to deal with if we're prepared to engage in secret surveillance of friendly nations for no other reason than to gain commercial advantage. This reputation of being an untrustworthy nation can only be exacerbated when our government, without notice, tears up trillion-dollar contracts with allied nations, as we've seen more recently with France. This is a pattern that we can't see continue. Australia's once proud reputation as a standard bearer for the rule of law and civil rights and freedoms has suffered some serious blows in the last 20 years. Our treatment of people seeking asylum on Australia's shores, the appalling justice gap for First Nations peoples being notable. And these prosecutions here have not gone unnoticed internationally. If our nation wants to be heard on human rights breaches in our region or further afield, we must regain and then maintain our reputation as good international citizens. That everyone's equal before the law and no one is above the law is fundamental to the rule of law and to a good justice system. It's arguable that those who authorised the bugging of Timor-Leste committed the common law crime of conspiracy to defraud. The then Attorney General's exercise of discretion to prosecute ought to have gone in the favour of Bernard Collaery and witness K, given the public interest in exposing wrongdoing. But they're facing criminal proceedings, while those who authorised and those who benefited from the covert surveillance remain untouched, above the law. That's just not acceptable. A free and independent legal profession is essential to the operation of the rule of law. People must be able to prosecute their rights and defend themselves in a fair trial. Attacks by the state on individual lawyers just doing their jobs is a dangerous threat to that fundamental tenet. If lawyers are prosecuted when they act for clients who have offended the government of the day, then an important means of holding government to account is lost. The principles of legal professional privilege provide that communications between a lawyer and client are confidential. This is fundamental to the proper operation of the justice system in a liberal democracy like Australia. People must be able to speak frankly and fearlessly to their legal representatives without fear that what they say and the advice that they're given can be got hold of by the other side. Yet George Brandis, former Attorney General, said, "No lawyer can invoke the principles of lawyer-client privilege to excuse participation, whether as a principal or an accessory, in offences against the Commonwealth." In our view at the Council for Civil Liberties and among the legal profession of Australia, at present, the NSI Act is tilted too far in favour of national security and against the rights of accused people. The Law Council and the Council for Civil Liberties have advocated for law reform, including a public interest defence, and the appointment of contradictors or special advocates who can speak on behalf of any party forced to leave a courtroom before confidential materials canvassed. If the government acted illegally, as we think it did, then disclosing information for the sole purpose of exposing that illegality should not be prohibited by Section 39 of the Intelligence Services Act. There's an urgent need for a public interest defence here, allowing an accused person to argue that disclosure of the confidential information was in the public interest, and for that reason it was not against the law. Reform is needed to recalibrate that balance between the requirements of open justice and protecting the community in terms of national security. Thanks, Catherine.
Thank you very much, Pauline, for sharing with us your reflections on Bernard's case and the issues it raises, especially the need for urgent reform of the NSI Act. Now, we've had a number of questions come in from the audience, and I'd like to take the opportunity to raise them with the panel. Bernard, I won't direct any to you because I don't want to put you in a difficult position, but of course, please feel free to contribute if you have an opportunity to do so. The first question that we've had touches on something that Pauline referred to, and that's the role of the ministers of Attorney Generals in this process. And the question is asking, could the Attorney General bring this outrageous process to an end if they were so minded?
Yes.
Pauline, do you have a comment on that?
Yes, I'll start, but I'm sure that Stephen might have something to say about that too. But absolutely, it's well within the remit of the Attorney General as a party to the proceedings to decide to not proceed any further with them.
Okay, and Stephen, would you like to add something?
Yes, plainly, the Attorney General can withdraw the prosecution. If they decide to do so, there may be a question of whether they have to pay the accused costs. But the second point is, now that they are faced with the possibility of all of the evidence about previous behaviour on the part of the Commonwealth possibly becoming public, whether their interest in the prosecution will continue.
Okay, thank you, Stephen. We have a related question about the role of the Commonwealth Director, the Director of Public Prosecutions, and how do they decide whether to open, continue, or drop a case? Are there rules around this? Does the Director have to give reasons for their decision?
Well, it depends. There are a number of different possibilities. Ordinarily, the DPP doesn't have to give reasons. A decision is taken to launch a prosecution, and no reasons are usually given for it. One assumes that the DPP had sought advice from his or her department and simply acted on it.
Okay, all right. Thank you. Pauline, did you wish to contribute to this response?
No, look, I mean, the DPP has pretty broad discretions, basically, and they're not obliged to give reasons, though sometimes they will.
Okay, all right. Thank you. Another member of our audience has asked how this particular case fits into the global problem of silencing whistleblowers, so like Manning, Assange and Snowden. They're asking whether there's international support perhaps to be harnessed.
In the just before the turn of the century, in the 1990s, a committee looked at the question of these security prosecutions, and it considered the question of whistleblowers, and it recommended that there be a provision in relation to whistleblowers. Unfortunately, the government decided not to act on that, so that at the moment there is no provision which makes life easier for whistleblowers.
Yeah, I'd echo that. There really are no sufficient protections for whistleblowers in Australia, and internationally that seems to be the case too. And we've, as you say, we've seen the persecution of people like Julian Assange and Snowden in ways that really don't seem proportionate to the alleged wrongdoing that they've committed. It's pretty disturbing to see people imprisoned, incarcerated in whatever way, in the ways that those people have been.
Okay. There's a question that's we might twist a little bit to make it related to what we're talking about now, which is reform of the relevant laws. The question was what is the federal opposition's position on the matter generally, but do we have any sense of the federal opposition's position on the necessary reforms?
I don't know about the necessary reforms, but I believe that the opposition is wholly opposed to these prosecutions and to the secrecy of them.
All right. We have a question, and it's an interesting one, and it's something you spoke a bit about, Pauline, and the circumstances in which national security should properly be invoked. It's noting that politicians use national security interchangeably with commercial interests. And how is it that the same can occur in court? Do they have the same definitions, these terms, in court, in the way that politicians use them?
Look, I don't think they do, but certainly under the legislation being invoked in these proceedings, the Australia's commercial interests can be part of the national security, but I don't think that the legislators, when drafting that legislation, were contemplating merely getting the upper hand in a commercial negotiation when they're talking about Australia's commercial interests. It's a real stretch to say that trying to get the upper hand in negotiations against a friendly nation is something that would have been contemplated. It's but it's a question of statutory interpretation as to what that actually means, and it's a big question that needs to be answered. And if it does mean that our government's allowed to do the sorts of things that it did in this case, then that's a piece of legislation that needs reform.
Catherine, if I could come in there.
Please do.
The Intelligence Services Act empowers ASIS to undertake work abroad, and broadly on a number of fronts, but relevantly for our national economic benefit. There are fundamental jurisprudential questions in the meaning of that term. I mean, we can enrich Australia by invading another country. We can enrich Australia by intercepting a gold shipment belonging to two different countries and stealing it. That would be to our national economic benefit. The fundamental jurisprudential question is, should all those terms, foreign affairs, national security, and supporting Australia's national economic benefit, be subject to the fundamental test of lawfulness? And can we connive, defraud, steal, invade for our national economic benefit? Are we still a colonial power, et cetera, et cetera? So the Intelligence Services Act fails to spell out, presumably because those involved in the drafting of it and the bipartisan, I must say, Parliamentary Intelligence Committee that agreed to those terms would never contemplate a meaning of national economic benefit based on fraud, for instance. And so have we reached the stage where we really need to more fully define those terms in the Act so that it is understood that national economic benefit does not mean under our domestic laws, law breaking? There are the vast problem that the courts are presented with now is that there's always been an assumption that the executive would act lawfully. There's never been an assumption that we wouldn't be protected by the executive. And the courts, and the High Court particularly, has been careful not to get involved in executive exercises of discretion, particularly on national security. And the problem for our country is the quality of our executive. Now, Stephen can speak more openly about that, but our problem is with the executive. It's clear that when our parliament passed laws, it assumed that we would act lawfully to sustain our national economic benefit. Thanks.
All right. Thank you, Bernard. Now, Stephen, would you like to speak more on that point?
Just one point here. The whole of these events surrounding the bugging, the listening into the negotiations, the use of the information so gained, and the way in which we dealt with the invasion of Bernard Collaery's offices, the sacking of his rooms and seizing the witness case affidavit and his advice, all the rest of it, are prime among the reasons which I put forward for the necessity for a National Integrity Commission. The second point that I wanted to make, going back to the question before about whether these prosecutions should ever have been brought at all, is I have wondered whether anyone gave consideration or adequate consideration to the effect that doing so would have upon the Timorese, this very, very poor nation. China is doing its best to offer it money, to join it to its Belt and Road proceedings. How could we do more to drive Timor into the hands of the Chinese, our neighbour immediately above us, next door to us, than the proceedings we are presently taking?
Thank you, Stephen. It's a really important point, isn't it, about not only the immediate consequences of these cases, but also very, very wide-reaching global consequences for us also. Now, I want to pick up with a final question, because unfortunately we don't have a great deal of time left, on something that you raised, Stephen, in relation to the Commonwealth's behaviour as a litigant in this matter. And we have someone who has asked whether the Commonwealth has ever been found to be a vexatious litigant, or had to pay compensation or damages for a prosecution that's been wrongly brought. Stephen or Pauline, are you aware of any such cases?
I'm not aware of any such case. I think judges would be pretty timid to arrive at the conclusion that the Commonwealth was a vexatious litigant, although the likelihood of it seems to be increasing these days. I do not know of any such case, though.
I've not heard of any such case either, but I think that the point that Stephen Charles made earlier was that the Commonwealth is meant to be an ideal litigant, which means not adopting unfair tactics, etc. And perhaps he might like to expand on that.
Stephen, would you have any additional comment about how it is that the Commonwealth should have behaved and should behave in this matter?
Well, I think that they should have given very substantial legal aid to both witness K and to Bernard Collaery. They were left in a position where they were completely unable to go overseas to seek the sort of expert evidence which the Commonwealth certainly wanted to use and did use. Secondly, I think that any attempt to prevent Brett Walker from acting for Bernard Collaery, and must say that's the only conclusion that I can draw from the court's judgment, which I've quoted to you. Any attempt to stop that happening, I think, is disgraceful.
Thank you. And that judgment you refer to, Stephen, we'll ensure that that is tweeted out later so that anyone who wants to go and have a read, I think you referred specifically to paragraph 17 to 19, is able to go and refer to it. Now, I did say that was our final question, but I have seen one that I think is probably a very good note to end on, and that is whether there is anything we can do, how can we best support Bernard in his litigation and to ventilate the issues of principle more broadly in the community. Pauline, we'll perhaps start with you. Would you have any comment on that?
Look, I do think that there is power in writing to and going to see your local federal member and talk to them about your, let them know in no uncertain terms how you're going to vote if they don't talk their colleagues into changing their approach in these sorts of matters.
And Stephen, any final comment before we close?
I think people should let their local members of parliament know their attitude to these proceedings if they have strong views about it. And equally, particularly, I think, in relation to the secrecy of these proceedings, the idea that one would accept first that anything in relation to the identity of members of the Secret Service or of the actions of members of the Secret Service, the way in which particular operations might be carried out, of course, should be kept secret. But the idea that anything about the appalling behaviour of our foreign affairs personnel and the negotiators in the proceedings and the way in which the rule of law has been trashed by our present government, which from time to time proclaims we live under the rule of law. The idea that any of that should be kept secret is nonsense.
Thank you, Stephen. So on that note, we do need to finish up for today. I apologise if we haven't got to your questions. There were many more excellent ones there. I hope that we'll have the opportunity to meet again in the future with Bernard able to speak more to current history also. So thank you to you, Bernard and Stephen and Pauline, as well as to all of you who have joined us for this important conversation today. You can find out more about the work of the Centre for Public Integrity at our website, and make sure that you sign up to our mailing list for updates about research and future event information. I know we have one with the Stretton Institute on the South Australian ICAC changes on Wednesday, the 20th of October. Thank you, everybody.
Thanks very much.